I got 4 questions for you that we'll just take a little bit of your time on that. But if you look at that card, the first question, you're probably already thinking it, and you know, because Nevada, it's funny when I show that card, around the nation, everybody goes, look at Nevada. Look at Nevada. The first question that comes to people's mind that we ask people is why? Why the difference? And it's kind of funny, the answers that come out, actually. When you ask someone, you really want an answer, and you ask them why the difference, it's really amusing, and I'll talk about some of the answers that come out. But here's what's amazing. The promise at statehood, your Enabling Act, our Enabling Act, you guys were made, Nevada was admitted as a state in 1864. The language of your Enabling Act says the people of the state forever disclaim all right and title, not jurisdiction, but all right and title to the unappropriated public lands. And many people act as if there's a big period right there. That's only half the sentence. The rest of the sentence reads, until title thereto shall have been extinguished, those lands are subject to disposition by the United States. And if you look at that same language, that's the same language in the Enabling Act of North Dakota and South Dakota and Oklahoma and Nebraska and Louisiana and Mississippi. And the Supreme Court has said other states that have very similar language in their Enabling Acts, it's different, but it's related. The Supreme Court has said repeatedly, it means the same thing. So the promises on both sides of that map are the same. Why the difference? Why the difference? There came a time when the Western states got completely fed up with that. You know this history well, I think. They got fed up with that and said, you got to keep your promise. They got together, they banded together and sent resolution after resolution, delegation to Congress and said, why aren't you keeping your promise? We can't tax the land to educate our children. We can't grow our economies and provide good paying jobs, and you're hoarding all of our abundant resources and minerals, right? Does that sound familiar? That was in 1828. In 1828, the Western states, by their own description, they called themselves the Western states, were Indiana and Illinois, Missouri, Louisiana, Arkansas, Mississippi, Alabama, Florida. Florida said, we're worse off than all the Western states. Illinois, the federal government had controlled 90%, like Nevada, 90% of their land for decades. Missouri, they had controlled 90% of their land for decades. But they got together and said, you have to keep your promise. You know, that was back when men were men and states were states. And they said, you will keep your promise and all that implies. And they did. Look at the map. 3 to 4% federally controlled lands east of Colorado. Why? That's your second why question. Why did they succeed? Why were they successful in compelling the federal government to keep the same promise that they've made to us but have failed to keep? Isn't that an important question, don't you think? This has already been done. So it's funny the newspapers want to say, oh, you're doing something radical. No. We're simply following the example of states that had the same problem. And by the way, on the website, there's a resources tab. And there are videos and there are documents and all sorts of things that go through this history. In fact, you'll see on the front of the website, it says, Congress and the Western states make our case. And so the Public Lands Committee, the Congressional Public Lands Committee in 1828 said, if these lands are withheld from the states, which are the effect of the present system, in vain may those people expect the benefits of well-settled neighborhoods so essential to the education of their youth. When these states agreed not to tax the lands until they were disposed, they rested upon the implied engagement to cause them to be sold within a reasonable time. They said no just equivalent has been given those states for the surrender of an attribute of sovereignty so essential to their welfare and an equal standing with the other states. In fact, they said, a remedy for this great evil, I completely agree with Congress for once, right? A remedy for this great evil is found in simply carrying into effect the spirit of the Constitution that knows no inequality in the rights or powers of the several states. That was in 1828. That was Congress in 1820. It's all on the website, so you can go there and look at that. But yeah, I don't know if he was still there, but Andrew Jackson, and by the way, Andrew Jackson was the president at the time. And this is fascinating. I don't know how much time we have, but this is really critical. There's, on that resources tab, there's a veto statement by Andrew Jackson. He's president in 1833. Andrew Jackson was born in 1767. By 1787, when Article 4, the property clause of the Constitution, when that was drafted, Andrew Jackson wasn't a 20-year-old in the basement playing video games. He was a 20-year-old lawyer in Tennessee. Tennessee was one of these states like us that was yet to be a state. So he was intensely interested in what's the process of creating new states, how does that work? Andrew Jackson spent his whole military career in Orleans and in all that territory that was yet to be states. And so when Andrew Jackson drafts the veto statement in 1833 that you'll read on the resources tab, although he cites all of the documents going back from 1780 forward and the solemn covenants that the federal government was only to hold land for two purposes: create new states, use the proceeds to pay the public debt. I mean, if you think about it, they're in the middle of a war in 1780, right? 1776, they had declared independence. Robert Morris funded the first 3 years of the revolution by himself, $2 million, lives, fortune, sacred honor. He was tapped out by 1780. They said, what do we do now? How do we fund this war that we're in the middle of? And they said, okay, we've got to do revenue enhancements like you've all been talking about this morning. We have to increase revenue somehow. And of the 13 now states having declared independence, 7 of them in their colonial charters in 1763 from the king, in their colonial charters, the king said, here's your boundary to your colonies. And by the way, 7 of you can have claims to the western wastelands, out to the West Sea, which was the Mississippi River. 7 of you can have claim to the western wasteland. But of the 7, 6 of them got nothing, right? They just got their boundary of their colony. But of the 7, even their claims overlapped. And so there was some dispute about, no, this is mine, no, it's mine. And by 1780, they're trying to figure out how to fund the war. And the 6 of the states said, we got to raise taxes. And the 7 said, hey, no sweat. We'll just sell some of this western land that we have claims to. And the 6 said, hey, wait a minute. We're putting our blood and treasure into this deal as well. We're going to come through this, and you're going to have these great big tracts of land, and we're going to have to raise taxes, and all of our people are going to flee our state and go to you. That doesn't work. And in fact, in the middle of the Revolutionary War, they were almost to the point of a civil war. They call it the Great Embarrassment. And so in September of 1780, the Continental Congress said, here's what we'll do. We'll hold the land. We'll hold these western lands to make new states and use the proceeds to pay the debt. And they came up with a resolution that the states looked at it and said, no, you got to do better than that. If we're talking about something as serious as you holding title as a centralized power, think of who they were, as a centralized power, you holding title to land, if we're talking about something that serious, it has to be very, very specific. And so they went back and tried it again, and on October 10th of 1780, they drafted another resolution that said the unappropriated public lands, that's the language still used in our enabling acts, right? The unappropriated public lands that may be relinquished or ceded to the United States by the states shall be disposed of for the common benefit and only to create distinct republican states with the same rights of sovereignty, freedom, and independence as all the other states. And they'll be disposed of on such regulations as Congress may prescribe for disposing of the land. Pretty clear, right? On that basis, New York said, okay, fine, we'll cede our land to you. And when they did it, though, they said, we'll cede the land to you only to create new states, use the proceeds to pay the public debt, and for no other use or purpose whatsoever. That was their exact language. And the other 7 states began to cede their claims to the United States. Actually, it was the Confederacy at that point, right? Now, 3 of them didn't cede their claims until after the Constitution. Georgia didn't cede its claims until 1802. Some people say, oh, that's just old stuff, Representative Ivory. What are you talking about? That's just old stuff. That doesn't matter. No, Georgia ceded its lands after the Constitution in 1802. And they said the same thing. We're only going to cede our claims to these western lands to you, create new states, use the proceeds to pay the debt, no other use or purpose whatsoever. 1784, Jefferson drafts a land ordinance that says the same thing. Only regulations for disposing of the land, equal footing, create new republican states. 1787, the Northwest Ordinance, this is all on the website. Northwest Ordinance says the same thing. The states will all be on an equal footing. And the states won't interfere in any way with the federal government's primary disposal duty to dispose of that land to create new states, use the proceeds to pay the debt. And the regulations will only be for disposing of the land. Then we get to Article 4, Section 3, which is the constitutional power on which these lands are managed, on which territorial lands are managed. And Article 4, Section 3, in the constitutional debate, there was 1 page of constitutional debate on this section. And they said, this section, Article 4, Section 3, is simply to preserve the status quo going back to 1780, in fact, back to 1763. They'd already had this great embarrassment that they were working over and said, we're just going to preserve that status quo. And so they drafted Article 4, Section 3 to preserve the status quo. It says, Congress shall have the power to dispose of and make needful rules and regulations regarding the territory. And nothing in the Constitution shall be construed to prejudice any of the claims that the United States or the states shall have under the Constitution. Think about that. You now know more than most lawyers know about Article 4, Section 3, because you don't teach that in law school. In law school, they say Article 4, Section 3 means the federal government can do anything it wants. Does that make any sense? When you look at that simple map, and you look at that manifest disparity, manifest injustice, and you realize that it's already been done before and that the promises are the same, kind of important that we understand what that means. More information on the website. But anyway, getting back to 1833 then. By 1833, they had paid off the debt from the war. How would that be? And so Henry Clay was a senator from Kentucky. And Henry Clay said, okay, we paid off the debt. We know we need to dispose of the land. That's indisputable. In fact, he called it the Great National Public Trust in the debate on the Senate floor. The Great National Public Trust, and it was done as a trust because that's the utmost good faith and loyalty. The highest duty known in law was a trust duty. He said it was a trust because if the federal government didn't keep its obligation to dispose of the land, there'd be no other remedy but a breach of the peace, back when states were states and men were men. He made that statement on the floor of the Senate. But what they said was because the debt was paid off, we'll take the money from disposing of the land, as we're bound to do, and we'll use that money as a slush fund. And when the states and counties do what we want, we'll give them some money. Does that sound familiar? And so it passed the House and the Senate, and it goes to President Jackson, who was born in 1767 and knew a thing or two about this whole history. And President Jackson said, you don't understand. These solemn compacts made in 1780 that created this trust where the federal government only held the land as a trustee to create new states and use the proceeds to pay the public debt, that was the very basis on which our nation was made. It solved the great embarrassment, and without that trust arrangement, we never would have had a constitution in the first place. And so he vetoed the bill. And in vetoing the bill, he made a statement that he said, these lands, the price of these lands shall be reduced and graduated, and after they've been offered for a certain number of years, the refuse remaining unsold shall be abandoned to the states, and the machinery of our land system entirely withdrawn. You got to read that. It's on the resources tab. It's phenomenal. It's about 8 pages. He gives the best, contemporaneous, most concise history of what our public land history is. That's why they succeeded in the 1820s and 30s, those great western states of Illinois and Missouri and Louisiana and Florida. The reason they were successful in getting the federal government to honor its promise to them was because they knew that history, and they knew their legal rights, and they banded together. And they simply refused to take no for an answer, whatever it takes. You have to dispose of our land because we can't educate our children, as you've all been talking about. You have to dispose of the land because we can't provide good-paying jobs and grow our economy, as you've all been talking about. We can't access our resources that we've been so abundantly blessed with and develop them in a responsible fashion because you're not keeping your promise. And because they refused to take no for an answer, and in every meaningful contact they had with Washington, they said, when are you going to keep your promise for our kids? When are you going to keep your promise so that people don't leave our state? When are you going to keep your promise so that we can provide good-paying jobs and access our abundant resources that we've been blessed with? And you can see that they succeeded. They compelled Congress to treat them as governing partners, and they ended up with what was called the Graduated Price Act of 1854, where they reduced the price, and ultimately would just give the land to the states. To Tennessee and to Hawaii, they just gave the land to the states outright. To Michigan, they started disposing of the land, and they just gave them 13 million acres and said, you dispose of it. We don't want to keep managing things up here. And they did.